Welcome to the Pioneers in Pixels audio podcast, hosted by Sanjay K Khetarpaal, CEO of Marketing Markers, a digital marketing agency. Here we have discussions with some of the leading attorneys. Disclaimer: the podcast is for educational purposes. Please reach out to attorneys for legal advice.
Hey, good morning, everyone. This is Sanjay K Khetarpaal, and I own a digital marketing agency based out of Englishtown, New Jersey. And today I have with me Adam Brown. He is our real estate attorney. He does estate planner. He does a lot of other things too, but we will learn about the primary topics, real estate and estate planning today. Adam, welcome.
Oh, Sanjay, thank you so much for having me.
Great. So without further ado, let's get into that. Adam, tell me about who you are, what you do, why you do, what's your story? Tell how you come to do what you do right now, like in real estate, estate law.
And that's a very good question. So I've had my own practice now for closing in on 6 years. And what's a good practice? It's a thriving practice. And a lot of people wonder, how did I get to where I am? So first, a little bit about me and about my background. So I've been practicing law for a little over 15 years. And my office is based in Summit, and I live right over in Westfield, New Jersey. Now, my practice is primarily real estate and estate planning, but my background is diverse. My background is litigation, some real estate work, estate planning work, some municipal court practice. So how did I land in this real estate and estate planning space? A lot of it is because those are the skills that I excel at. I am very good at working with different types of people, which is a key component of a real estate transaction, whether you're working with a client, a realtor, an adversarial attorney, and bringing people together and getting transactions closed. On the estate planning front, I'd like to think that I have very good people skills, and that's extremely important with estate planning because you're dealing with all sorts of people and very sensitive topics. Nobody wants to talk about death or what happens if somebody passes. So you really need to have the right personality and be the right person to deal with those types of clients.
Interesting. Thank you. This is really great. See, there's a lot of myths which we have, or I would say that not really myths, something or kind of close to that is, why should I hire a real estate attorney? Can I not have a real estate attorney? Oh, I'm going to talk to my a real estate agent to get me an attorney. So there are a lot of things that which is kind of a customer should be able to do by himself or herself, saying that I should hire a real estate attorney for this is a real estate transactions going on, and I have a right to do that. I don't want to wait for agent. But again, when you get into that space, I just wanted to break something that can somebody directly come to you and ask it? I think you can, but I just want to spend some time on that, saying that what a real estate attorney can bring to the overall transactions and how the customer can get benefit out of that.
Sure. So as a lot of people are aware, the housing market has been extremely active really since COVID, when it's been an extreme seller's market, and there's been a lot of changes in the market because of it. And as a result, attorneys have been getting involved in the purchase and sale process earlier and earlier because in a lot of instances, the realtor is in certain cases assuming the role of the attorney and how they are presenting their offers to a potential seller. And that's not really the role of a realtor. Okay. Mm-hmm. So usually, if I was a potential buyer or a seller, I'd be looking to speak with a real estate attorney really as soon as they are looking to purchase or sell, because the attorney has a very unique perspective in a real estate transaction. First, we're attorneys and we understand the legal aspect and what can or cannot go wrong and what normal course is. Mm-hmm. But also a experienced real estate attorney is a unbiased individual who is involved in many, many transactions. So we have the legal insight, but then also the insight from our experience, right? And as far as who you should hire as a real estate attorney, the experience piece is really what is so important. And the reason why is, as I was just touching upon how the market has changed a lot in the past couple of years, the real estate market is a living, breathing thing. It sounds crazy, but there are trends now that are currently happening in the market that were not happening 3 months ago. And there's also things that are very commonplace today. We're entering the spring/summer market, which were not commonplace a year ago or 2 years ago or 3 years ago. So a lot of people assume that they can just hire any old attorney to handle their real estate transaction, but that's not true. And in my transactions, when I'm on, say, the buyer's side and the seller is being represented by an attorney that does not truly specialize in the real estate space, I usually pick up on it immediately, and I can see it by how they're approaching their transaction. Okay. Mm-hmm. And that's why it's really so important that the client is speaking with an experienced real estate attorney and using an experienced real estate attorney.
Interesting. I think this is the most critical part of it, because there are a lot of things which can go any directions, and if you don't have a right attorney on your side, it's a negative on yours. So when you do a real estate transaction, there are a lot of disputes might be happening. So is there a process that, hey, the dispute happened, and dispute could be anything, and probably you can explain and give a few examples of like, hey, the dispute can be of this type, and how can that be resolved, or how can you help them resolve that, or what kind of dispute you have seen in your life, and things like what happens, things like. So just give us some examples so that our customers can, or our listeners can kind of connect, saying that, oh, when I'm going here, these kind of disputes can happen, and that's the reason a real estate attorney is needed, and how you solve that in your experience. Give us some examples that might help.
Sure, Sanjay. So as you probably heard me stress over and over again, the importance of experience. Yeah. So one of the challenges in real estate is every transaction is a big money transaction to the parties in it. I'm in $3 million deals where it's a lot of money, and I'm also in $200,000 deals where that's a lot of money, right? Whoever's buying or selling, it's a lot of money to them. And one of the challenges in a real estate transaction is that we are not in court. There is no referee, okay? There's a buyer on one side, a seller on the other side. Typically, both sides have a realtor and an attorney. And in the event that there is some sort of dispute or some sort of problem, the parties really need to come together to figure these things out. And that's where the value of an experienced attorney and experienced realtor really comes into play, right? Because how do you solve these problems? Mm-hmm. And I'll give you just an example of, types of things that we encounter in a real estate transaction. Okay. So in a normal deal, the parties go under contract. And then once they're under contract, that's when the buyer is going to do their home inspections. Mm-hmm. Okay. And typically the buyer sees the house once or twice, places an offer for the property. The offer is accepted. They go under contract and do our home inspections. That day of the home inspection could potentially be the second or third time they have ever seen the property. Mm. Okay. And they've already committed themselves to spending whatever the agreed upon price is. Right. There are home inspections where problems with the property are learned. There are home inspections where a buyer may determine that based off these problems, they need certain things addressed, or they can't go forward. They don't want to go forward. Right. One of the jobs of the buyer side attorney is to present those types of issues in an effective manner to the other side to reach a resolution. Okay. Right. Mm-hmm. And similarly, on the seller's side, once we are under contract, the seller's putting a lot of faith in the buyer that the buyer is serious about the property and planning on taking this matter to closing. Okay. Now, there are instances where there is a dispute, where the buyer and seller do end up at odds with each other. And in those unfortunate situations, it's really more important than ever that you're with the right attorney. I mean, I think in law, just like really any other business you have, any other business, I think this applies to all businesses, things are easy until they're not. And when they're not, you really want to make sure you're in the right hands and you've chosen wisely. Okay. Now, let's say hypothetically, the parties are at odds with each other. You know, there's a breach of contract situation and things have gotten contentious. Okay. One of the values that I provide is that I do have a litigation background. And while that's not the primary focus of my practice, I do understand the courts. I do understand the framework of how to pursue a matter in the courts if that's what's required. I also know how to frame proper defenses if I believe that we're heading towards a situation where my client's the one who's going to be accused of being a breach of contract or something like that. But it's fairly unusual for these matters to end up in the court. And the reason why is twofold. Typically on the seller side, as upset as they may be with a buyer, they want to sell the house and they don't want to end up in a 2-year litigation, right?
Yes.
And then similarly on the buyer side of a transaction, they don't want to see their deposit potentially tied up for that 2-year period. They want to move on and they want to buy a home as well, right?
That's correct.
And just kind of going back to the value of a experienced real estate attorney is that chances are, A, we know how to handle these types of situations. And then B, there's a pretty good chance that I've facilitated a strong relationship with the attorney on the other side. Because one of the jobs of being a good attorney is not taking things personally. Right. You're here to represent the interests of your client. That's first and foremost what you're here to do. Right. And just because maybe your client's very upset or the other side's very upset or tensions are very high, you can't lose sight of your role in this transaction is to try to keep things calm and reach that resolution. I think that's one of the skills that I do have and something I do provide to my clients.
It's interesting. So I was just, when you were talking about it, about the challenges and then dispute and stuff, I was like thinking about one thing which just crossed my mind was like foreclosures, because market and pandemic, and you mentioned all of that stuff. I like the foreclosures happen. Any advice do you have for the homeowners facing the foreclosures?
Yes. So my advice to somebody facing a foreclosure situation is don't stick your head in the sand. That's the problem that I encountered quite a bit, where when clients do have, especially in the market that we've been in, one of the interesting features of this market is that homes have been increasing in value, which is terrific if you're a homeowner. And some of those homeowners are in foreclosure. So it's not so uncommon that I'll encounter a owner who, let's say a house is worth hypothetically $700,000 and they haven't paid their mortgage for some time. They've gone through the foreclosure process. But the mortgage is only a $300,000 mortgage. With costs and fees and everything, they still have several hundred thousands of dollars of equity in their home.
Right.
That's a home that can be sold for a profit if there is time. Okay. But what I see a lot of is it's not a happy situation. Nobody wants to be in a foreclosure scenario, and they'll wait and wait and wait and wait until they're on the eve of a sheriff's sale where they're going to lose their property to finally start doing what needs to be done to sell it. But at that point, it's the 11th hour, right? You're not going to have the opportunity to list your property with a realtor and field offers and stuff like that. Chances are you're going to run into some sort of, bottom feeder scenario where somebody is looking to purchase your home at a drastic discount.
Yep.
Sanjay, does that make sense?
No,
so it's
totally,
really staying ahead of these things. I mean, just to give you like an example of something I encountered recently, which very similar fact pattern, but this particular seller was ahead of it, where the seller ended up in a foreclosure situation, but the property had approximately $200,000 of equity.
Mm.
So even though they were in a foreclosure situation, because they didn't wait till the last second, they were able to sell the property to a buyer, interested buyer at top dollar, and walk out with something versus losing everything.
Mm-hmm. Interesting. Yep. That's a good advice. Don't wait till it's too late. So I'm going to just
right. And also because of why we're here, talk to an attorney.
Exactly. So I'm going to switch the gears and move to a estate law part of it. So there are so many questions. I think the topic itself is very, very big. So I'm just going to say that why do you need an estate law attorney, and what an estate law attorney can bring to the whole planning part of it? Just start from the top level. I just want to go into deeper.
Sure, Sanjay. So you are correct. It's a big topic. There's so many different options and different things that could be discussed. But I remember years ago when I was meeting with a financial planner, right? And I was kind of telling him my ideas and what I wanted to do. And he said, well, the important thing is that you're here. That's step one. You've taken that first step. And the second thing is that you're doing something. Right. So I think about that when I think about estate planning, is the worst thing you can do is do nothing. And that's what a lot of people do. Right. Even your most basic will is still better than not having anything. OK, but let's kind of give a brief overview of estate planning and what the concerns of your average person and kind of the different phases of estate planning in somebody's life. All right. So the three key estate planning documents is the will, which is the document that lays out what happens when, unfortunately, you pass. There's the healthcare directive, which is a document which takes effect while you're still alive, typically when you're incapacitated or can't make decisions for yourself, which lays out your healthcare wishes. And then third is the power of attorney, which gives somebody the right to make financial decisions on your behalf, typically when you can't make those decisions for yourself. And that would cover financial decision making. Okay. So those are really your three main documents. And there's also trust and some other things that people could do. Right. So there's really three different phases of estate planning, or typical phases that I see. Right. So first, usually newly married couples, maybe they have a child on the way, maybe they recently purchased a piece of real estate. That's my classic first time estate planning client who's going to come to me and they have nothing on paper. They've gone through some recent changes. Now they're married. So they have to think about what happens to the spouse in the event that they pass, right? Now they have an asset in the house. So it's not just we have a few bank accounts. They have a significant asset and they want to make sure that that's set up properly. And then also when they have children, or perhaps there's children in their future, they have to think about who the guardian of that those children will be in the event that, unfortunately, they both pass. And also who is going to be entrusted with handling their assets for the benefit of their underage child. Okay. So that's usually your first phase. And then the second phase is typically when the children are now of adult age. Maybe they've left for college. And hopefully by that point, the person who's having their new will drafted has accrued significant assets. And they're going to give more thought to whether they want to keep things the way they are. Maybe now they want to include one of their children as an executor or have some sort of beneficiary role in the will. And then usually the next phase is when they're approaching retirement and giving a little more thought to that phase of their life, whether what happens if I'm in an assisted living facility, how is that going to work? And that's usually when we'll start entertaining whether some sort of trust makes sense. And it's kind of like usually an advanced stage of estate planning.
Interesting. So no, this is so interesting. It's such a vast topic. The one thing which I mean, what you talk about various stages or phases, I'm saying that you can have a will when you are like very young. And so how often or I think probably I know the answer, but I just want to run it out. How often somebody need to go back and renew their will or just check it again? Versus I've seen people just have the will, and then when something goes sideways or you're not there, they open up and say, oops, there's a lot of discrepancy. I should have touched upon it like 10 years ago or 15 years ago. I don't know how often I should be touching that will and doing something about it, because it cannot be just one time and just forget about it.
Right. So usually the time to revisit it is when somebody's gone through a significant life change, right? Mm-hmm. So I look at life change as kind of described phases, but sometimes it's not uncommon that I have an individual who maybe recently was divorced, and now it's time to revisit those documents. It's never a bad idea, maybe every couple of years or so, to consult with an attorney, just to make sure that you know what you have and everything is the way that you want it. Typically, when a client comes to me and it's time to revise a will, and I ask them, well, how is this will, how was this will previously drafted? Usually the response to me is, we're going to bring it in, you can look at it. Because they don't even know what's in there. They don't know who the executors are. They don't know how the beneficiary structure is. And it's not uncommon that I'll kind of go through the will with them and explain how things are currently drafted, because what's really important to me is I want to serve my clients properly. And sometimes we'll have situations where maybe it's time to revise a will, but some of the secondary documents are fine just the way they are. And that's what I'm going to tell the client. It's not about how many things I can get a client to pay me for. It's about making sure that the client has the documents they need and that those documents are properly drafted. And you would not believe how many times there's things that I'll point out in an existing will with them, and they have no idea it's in there. Mm-hmm. Like maybe it's a whim they had 10 or 15 years ago, and now things have completely changed and it's still sitting in there. And if it's in there, that the executor needs to honor it. That's what's in there. That's how it's going to be. Sometimes I'll have something in there where the individual can name whatever beneficiary they want. And it's not uncommon that maybe they'll envision giving a gift to maybe some sort of educational institution or a nonprofit or something along those lines. Right. Mm-hmm. And I had a situation not that long ago where I'll just give you like an example where the way the previous will was drafted, the individual was giving, I believe, 5% of their estate to a nonprofit. And this individual did have significant assets. Okay. And I think in their mind, all right, well, maybe this will be a $25,000 or $50,000 gift. But based on the assets they had, this was going to be something far greater. Mm-hmm. So when we revised the will, we put an actual dollar amount in there versus leaving it open-ended with a percentage.
Oh, okay.
Just as an example.
No, it's interesting. So there's one thing which I have when I've been talking to a lot of people and my friends and everybody else, people ask the question, I don't need a will. Why do I need a will? I'm fine. So I just want to ask that question. What is a disadvantage of not having a will? What could go wrong? And what kind of situation our listeners can be if they don't have a will? What will happen? Give me some scenarios. Sure. These things are going to happen.
Absolutely. Well, first, if you don't have a will, then chances are you don't have a healthcare directive or a power of attorney either. Possible. So you have nothing, right? And those documents are really just as important as the will because those lay out your wishes while you're still alive, right? So if you don't have a healthcare directive and you end up in the hospital one day and you can't make decisions for yourself, and unfortunately it's a reality of life that this will happen, there is no legal document which lays out your wishes or gives anybody authority to make those decisions on your behalf, right? And the same thing with the power of attorney is, let's say, unfortunately, you're in an assisted living facility at some point. There's nobody to handle your affairs, all right? But back to your question, what happens if there is no will? So if there is no will, then the decision of what happens to your assets and how that's administered will be based on the laws of the state that you live in. You no longer have power over your affairs. Okay, so So like, for example, in a state like New Jersey, so when you have a will, you get to decide who you want to be the executor of your estate.
Mm-hmm.
The executor is the person who's going to resolve your affairs. They're going to gather all of your assets, gather all of your debts, pay out to beneficiaries. They're going to oversee everything. When there is no
the state is going
will.
to do. Sorry. Thanks for letting me interrupt.
Right, but no, it's okay. The executor, so the person that you have chosen, is going to have that power to make those decisions. This is when there is a will.
Okay.
Okay.
You don't have a
when
will.
There is no will,
Mm-hmm.
when there is no will, then the state is going to say, well, we don't know what your wishes were. So we have a framework for resolving an estate, but we don't know whether or not the people that are going to be appointed are the people you truly wanted. So just to give you an example.
Mm-hmm.
So when there is no will, there's something called intestacy. That's how you administer an estate when there is no will. Okay. And instead of there being an executor who is a decision maker that you've appointed, there's going to be somebody called an administrator.
Mm-hmm.
Right. And just to give you kind of an example of like the framework, right?
Mm-hmm.
So let's say you're married and you pass away. Then your spouse will be the administrator of the estate. And that's fairly straightforward. Okay.
Mm-hmm.
But let's say your spouse predeceases you and you have children.
Mm-hmm.
Let's say hypothetically you have 3 children.
Mm-hmm.
Under the law, the administrator is going to be your next of kin.
Mm-hmm.
But now you have 3 children.
Mm-hmm.
So one of them is going to have to be appointed as the administrator. And they are going to have to get permission from the other children to be that administrator. So they'd have to get a formal renunciation letter from the other children in order to be appointed as the administrator. So let's say hypothetically the children are at odds with each other or there's some sort of disagreement.
Mm-hmm.
Okay. They're going to have to hire an attorney to go to court and get somebody appointed. Or let's say a scenario where you do not have any, as explained, a lot of times there's different phases when people come to you for a will. And a lot of times that first phase is when they're recently married and starting a family. There are plenty of people that don't ever get married and choose not to have children. And a lot of the times when people make those types of decisions, they don't really give that much thought to their estate. And as a result, they are not married and they don't have any children. So what happens in that scenario in the event that they pass? Okay. So in the event they pass and there is no will, the framework for finding an administrator, instead of going down, if you're picturing a family tree, is now going to be going up. Okay. And they're going to be seeing if you have any surviving parents. And then if you don't, then they're going to look and see, well, do you have any surviving siblings? And they're going to keep on going on and on and on until they find somebody to name as an administrator. So we've all heard of those scenarios in which you'll see like a storyline about it of like a third cousin finding out somebody they barely knew passed away and now they're overseeing the estate. That's kind of your classic example of what can happen if you don't get a will.
Yeah, they get overnight millionaire. We have no clue where this is coming from.
Correct.
So yeah, it's interesting. So another part which I was thinking about when you were talking about these things, benefit of trusts, forming a trust in estate planning. What are the benefits? Should I do that? Not do that? What do you think? What should I do?
So it's really on a case by case basis, but let's talk briefly about what a trust actually is, or what your typical trust looks like. Right. So a will is what happens when you die, right? A will is this written document that explains what all your wishes are when you pass.
Right.
Now, a lot of people have an interest in avoiding probate or not having their estate have to go through the courts. Okay. So like one of the primary benefits of a trust is almost structured like a will, but it takes effect while you were still alive. And you could put assets into that trust and take those assets out of your name. Okay. And then the way a trust is typically drafted is instead of there being an executor, there's a trustee. And typically, if you're creating a trust for yourself, you're going to be named as the trustee and then also the primary beneficiary of the trust. So what you have done is you've taken that asset out of your name and put that asset in the name of the trust, and then given yourself control over that asset. Okay. But then let's say you pass away. When you pass, instead of going to the court, instead of the executor being appointed, what happens instead is there's a successor trustee, which would be your primary beneficiary. So let's say hypothetically, if you're married, maybe it would be your spouse, right? And then there would be a successor beneficiary. So now what you've effectively done is when you pass away, instead of starting with the will and the estate and the executor and the assets and going through the courts, what you've done instead is that asset has seamlessly transferred, or the interest in that asset is seamlessly transferred from you to your desired beneficiary. Okay. And then there could also be some desirable reasons to take assets out of your name, or there could be desirable reasons. There could be a tax component to it. There's a lot of different factors that we're not really going to get into, but that's kind of an overview of what a trust is.
Interesting. So I think I can keep on going on and asking a lot of questions, but I think we might run out of time really quick. So Adam, thank you so much for joining this podcast. I think there's a lot to go through it. What I would say that is, if you can give your email address, your website, your phone and everything, and if somebody has more questions, listeners have more questions, they can actually reach out to you and consult what they want to do, whether it's a real estate transactions going on or an estate planning going on. Would you be okay to share your details?
Sure, Sanjay, absolutely. So again, it's the Adam M. Brown Law Group based out of Summit, New Jersey. My email address is amb@ambrownlawgroup.com, and my phone number is 908-379-9731.
Great. And again, thank you so much, Adam, for coming and talking. And I mean, I think whatever you said, it's so much beneficial to our listeners. Thank you again.
Great, thank you. And thank you for having me.
Thank you for tuning in to today's episode of Pioneers in Pixels. We hope the discussion was enlightening and informative, giving you a clearer insight into the complexities. Remember to subscribe to our podcast on your favorite platform and never miss an episode. Join host Sanjay K Khetarpaal next time for more insights and interviews with leading legal experts. Until then, stay informed and empowered. This has been Pioneers in Pixels. Thank you for listening and have a great day.